Hello, Internet Law class, and welcome to this discussion of Internet law and copyright. As I mentioned last class, I wanted to give you a little bit of background about copyright law, what copyright law does in the United States. And I'm not expecting you to have a whole lot of detail about this if you haven't had a copyright class, but I do want you to have a little bit of background so you understand why the issues that we're talking about in this unit are important for Internet governance. So the first thing to note about copyright law in the United States is that it's rooted in the Constitution. Article 1, Section 8, Clause 8 gives the legislative branch, Congress, the authority to create legislation to promote the progress of science and useful arts by securing for limited times to authors and inventors exclusive right to their respective writings and discoveries. Now, of course, this doesn't mandate that there be a copyright law, and it doesn't state what form a copyright law has to take. But it does authorize Congress to enact a copyright law. The boundaries of copyright law are both substantive and temporal. That is, substantively, copyright law defines what is subject to copyright, what you have to do to get a copyright, and temporal, because notice that as a constitutional requirement, copyright can only be for limited times. Now, you might know, if you followed this at all in the news, that the term of copyright has grown over the years. There was even a Supreme Court case a number of years ago about the extension of copyright term, and in that case the court said the Congress can extend the term. At some point those extensions could be so broad that perhaps it doesn't really mean there is a meaningful term, but Congress can extend the term. So a limited term, but it doesn't specify what that term needs to be. So why do we have copyright law? What is the kind of theoretical basis for copyright? Well, there's one aspect of copyright in which it's thought of as a kind of social contract. Overall, what copyright is doing, or is supposed to be doing, is providing an incentive to authors to create, authors, artists, and so on, to create. So the thought is, if we don't have this incentive in place, it's going to be less likely that people create books and novels and other kinds of creative work. And the reason that it's going to be less likely is that once they create them and they put them out there, someone else will copy them or distribute them. And so it would make more sense to wait for someone else to create and then just to copy. That's at least the theory. So the idea is we'll give a limited monopoly over a work that has been created in return for the incentive to promote the arts and sciences, to promote this kind of creative work. And what do we mean by a limited monopoly? We mean that it's a property-like kind of right. The person who holds the copyright has the ability to exclude others from doing any of the things that copyright protects. And with that right to exclude, presumably comes some ability to charge a higher price or to gain some kind of return on what you've created. The benefit, as we said, is this incentive theory. The cost of copyright, social cost of copyright, is that it encloses the public domain, because there's otherwise no right in the common law to a property right in something like, a novel or a textbook or a painting. Common law property law doesn't cover those kinds of things. So in allowing a statutory basis for it, it actually takes something which otherwise would belong to the public and creates some kind of fence around it. So in the United States, the primary law that governs copyright is the 1976 Copyright Act. Now, there are earlier copyright statutes, and there are still works that were created under the 1909 Copyright Statute, which is the statute which immediately precedes the 76 Act. So there are some works that were created under the 1909 statute that still would be protected by copyright. And this dives a bit into the weeds of copyright law. If you take a copyright law class, you'll get into this. But the 1909 Act originally had a 28-year term of protection. There was then a 28-year second term of protection And then that second term of protection was extended by statute. So if you sort of calculate all this out, there are certain works, any work created before 1923, or I'm sorry, any work published before 1923 would not be subject to copyright. Works created after 1923 potentially could be subject to copyright under the 1909 Act. Under the 1909 Act, you obtained copyright by publishing the work with proper notice. So if the work was unpublished under the 1909 Act, you would not have copyright protection. Only when the work was actually published would you gain copyright protection. And there was a lot of case law discussing what publication means under the 1909 Act. In addition, you had to put proper notice on it. So when you see that little C in a circle, or the word copyright and a date and a name, that's a form of copyright notice. So under the 1909 Act, if you published without proper notice, you probably lost your copyright. There was also something called common law copyright. It's a bit of a misnomer, but the idea was that if you had an unpublished work, you would retain a different kind of right in it, which was the right of first publication. And so there's different disputes and cases and so on about those categories under the 1909 Act. Under the 1976 Act, which is the present statute, copyright protection subsists as soon as the work is fixed in any tangible medium of expression. And again, there's some case law about what fixation means and what a tangible medium of expression means, but all the kinds of things you might think of, a canvas that you paint on, a pad that you write something on, typing a document into a computer, all those sorts of things are fixation and a tangible medium of expression. So notice that under the 76 Act, you don't have to publish, and under the 76 Act, you don't need copyright notice or registration or any other formality. All of the formalities of copyright are done away with in the 76 Act, and the purpose of this is to coordinate U.S. copyright law with copyright law around the world. And again, this would get more into the weeds, and you would do this if you took a copyright law class. But there was an international treaty called the Berne Convention, created in the 19th century, which the European nations were a party to, that did away with formalities in copyright. And the U.S. was coming into compliance with the Berne Convention in the 76 Act. The basic requirement for copyright under U.S. law is originality. Now, originality sounds like it could be a high bar, and if you think of something like patent law says new, useful, non-obvious, and that novelty, that newness, and that non-obviousness is a higher bar. You really have to show that you've done something new. Copyright, not so. Originality is really a minimal requirement. Again, if you take a copyright law class, there's lots of case law on this. We're not going to get into the weeds of it in this class. So just realize under the present U.S. law, anything that is fixed in a tangible medium of expression, which is not hard to do, and that has a minimal degree of creativity, of originality, is protectable by copyright. So the vast majority of creative work that people do, the vast majority of intellectual work that people do, so long as it's being typed into a computer, recorded, this video that I'm doing right now, right? All of these kinds of things are subject to copyright. So the vast majority of content online, the vast majority of stuff in the content layer on the internet is subject to copyright protection in the US and or in other countries based on their copyright law, which if it's most of the countries in the world is going to be consistent with the Berne Convention. So what does copyright protect? Remember I said copyright is a right to exclude, and in that sense it resembles a real property kind of right. What it protects is reproduction, that's copying, but also distribution, display, performance, and transmission. Now you'll see as we look at a couple of the cases we're talking about, and as we think about the context of this in internet law, the reproduction right, of course, is going to be important, and historically in copyright, the reproduction right has been important. The distribution, display, transmission, those rights historically in copyright were important in, say, the film industry or television or places where there was a technology that supported this. Now with the internet, any of us can be a publisher. I'm creating this video, I'm going to put it up on YouTube. You're going to have the ability to look at it. If you, technologically, if you wanted to, you could easily use screen capture software and make a completely lossless, perfect reproduction of it. And then you could easily put it on YouTube or some other platform or Twitter or whatever yourself and publish it to the world and transmit it to the world. So this is something that in the past 20 years is really entirely new. Each and every one of us has the ability to make a perfect copy with perfect fidelity and to transmit it all around the world. And that's why this becomes really important as a matter of internet governance. As I mentioned, under the 1976 Act, there are no formalities. You don't have to put on a notice, copyright notice. You don't need to register the work. Now you might ask, well, why do people still put copyright notices on their work? Why do people sometimes still register their works with the Copyright Office? Because there are advantages to doing so. There are procedural advantages, and in particular, if you want to bring a suit for infringement, this can become really important. Again, don't worry about it too much. Don't get into the weeds of it. If you take a copyright class, you'll get into the weeds of it. So what constitutes infringement of copyright? If you think about patent law, again, by comparison, what constitutes infringement is you have a set of patent claims. Those patent claims define the scope of the patent. There are all kinds of legal doctrines about how to interpret and read those claims, but once a court has construed the claims and said this is what the patent covers, then we look at the accused device, the allegedly infringing technology, and we say, how does this map onto these claims? Now there's some other tweaks, the doctrine of equivalence, some other things under patent law. Take patent law, you'll get into that kind of detail. But it's a different kind of dynamic in copyright, because in copyright we don't have a set of written claims. In copyright we have the allegedly protected work, and the test is basically substantial similarity. What is substantial similarity? That's a pretty amorphous kind of test. Again, if you take a copyright class, you'll learn about things like abstraction, filtration, and comparison. How we take the original work, we kind of pull out of it stuff that might not be protected by copyright, like ideas are not protected by copyright. Simple facts, the fact that the Declaration of Independence was signed in 1776, you can't copyright that fact. So things like that, we'd strip out, and then we'd make some comparisons. But at the end of the day, it's a kind of fuzzy judgment. And the fact that it's a fuzzy judgment, again, can be important because for our discussion of internet governance, because it's not an absolute. It's a matter of judgment to determine, is this really infringing or not? And there can be lots of gray areas. Now, as we've already sort of mentioned, copyright is a kind of bargain. Copyright is not something we usually think of as a kind of common law right. It's created by statute for specific reasons. And the trade-off is that we're taking some things out of the public domain under copyright. So in order to kind of balance that trade-off and balance the interest in the public domain and balance that interest with free speech interests and the like, copyright is not absolute. Copyright does have limitations, and one of the really important limitations is the idea of fair use. So fair use had an existence in the doctrine under the 1909 Act in case law, and it's brought into the statute in the 76 Act in Section 107. So there's this kind of preamble language or this introductory language in Section 107, and what you want to see is that there are 4 factors to any fair use analysis. So fair use is also not absolute. It's a multi-factor test, and it can be very difficult in marginal cases to determine whether something really is fair use or not. So, and we'll look more at these factors when we talk about the Google Books case, but the purpose and character of the use is very important because the court's going to look at whether the use is transformative. Is it doing something really different than the original use? The fourth factor, the effect on the potential market value, also is really important. And it's often tied to the first factor. So if you're doing something really different with the work than what the original work does, you're not likely taking away any of the original author's market, any of the value that the original author has in the copyright. And so therefore it's more likely to be found to be a fair use. If you're doing something that's pretty close to what the original use was, then you're more likely to be impinging on the original author's market, taking money out of the original author's pocket, and it's less likely to be found to be a fair use. The middle two factors also still have to be considered and can be important. So the nature of the work, the more creative a work is, the less likely it's going to be found to be fair use. The more factual a work is, the more likely it's going to be found to be fair use. So, if I write a creative song and you're using snippets of my song, clips of my song in your song, then it's less likely to be fair use under this factor because it's a creative. If I'm doing these slides and I'm just describing the fair use factors, and you use a clip from my slides, you copy the screen that you're looking at right now, for example, you're going to have a much better claim of fair use because it's just factual material. And then the amount and substantiality of the portion used. So if you use the whole work, it's less likely to be fair use. If you're using a small portion, it's more likely to be fair use. So if you just take a screenshot of this one slide and you don't use this whole presentation, more likely to be fair use. If you just copy this whole video and dump it in, less likely to be fair use. Although there are exceptions to that. I mean, music sampling is an interesting one here because a song that has a really memorable riff, just copying that few seconds of that riff, could be enough. It all depends on the context, very context-specific kind of determination. All right, the last piece of statutory information before we dive into some of the case law is the Digital Millennium Copyright Act, the DMCA. So the DMCA was created really for the internet, in response to the internet, and there were some early cases. I mentioned these in class last week, but there were some early cases suggesting that an internet service provider that is hosting user-generated content could be liable as a publisher under a defamation claim or a copyright infringement claim for the user content. And there was some recognition at the time that sites that are hosting user-generated content need some kind of protection from that sort of claim, or otherwise this sort of whole experiment of the internet wouldn't really function in the way that we really want it to. So the DMCA in its first section provides a limitation to ISPs for transitory content, that is just content that's flowing over their servers and systems. The second section relates to things that are cached in the system, in other words, that are kind of held temporarily in the system while information is flowing across the system. The third section is the one we're really going to spend time looking at in this class, which is copyright infringement, hosting services, and the notice and takedown provision. And what the notice and takedown provision says is that for user-generated content, the host is not going to be liable for contributory copyright infringement if they have a policy in place, and the statute kind of defines what kind of policy has to be in place, but that allows the the alleged copyright owner to submit a notice, and then when that notice is submitted, the allegedly infringing material is taken off the site, and then there can be a process if there's a dispute about whether the material is really infringing or not. Now this is going to be important for a couple of reasons that we'll talk about as we get into the case law, and then also as we talk about the proposed European copyright directive. Because remember, copyright is not absolute. You don't have copyright in facts or ideas, and there is always fair use, which is really properly viewed not just as a defense to a claim to infringement, but as a limitation on the substantive right of copyright. So it's pretty easy for an alleged copyright owner to get something taken down. You just have to submit the notice. And it can be harder for the average user to get something put back up, particularly if the claim is really a claim of fair use. So some advocates argue that this really impinges on kind of the design of the internet, because it gives the copyright holder, or the alleged copyright holder, much more power over the content layer than they really ought to have, given the actual scope of copyright and the nature of the fair use doctrine. So keep that in mind then as we start to look at some of the cases and other materials that we have to look at in this unit.